This is my friend David Gammill, former LA County prosecutor, and now he's a civil trial attorney. So, hello, my friend. How are you?
What is going on? I'm well. How are you?
I see you got the memo about lemon yellow to wear this morning. I appreciate that.
I like us to match, just like the old days.
How are you doing?
I'm good, man. I'm good. How are you doing?
I'm good. What did I catch you in the middle of?
Oh, a very, very busy morning of lawyering.
General lawyering. Is that how you bill that to your clients?
Yes.
2.5 hours, general lawyering.
It's lawyering. I might have been checking out the lineup for a music festival I'm going to later today, but definitely a lot of lawyering.
Is that what is that? Is that the one down here in South Bay?
Yeah, the Beach Life Music Festival.
Yeah, you asked me about going to that, and I said, I've got 3 little kids. I can't leave the house. And you're like, well, you have to continue to live. And I felt bad, and now you're going, and I'm missing out.
Catch up to me in a decade.
Who is playing at that festival?
Well, the Diggable Planets are playing. I don't know the average age
cool.
of your viewership, but some of them will be excited about that.
Yeah, I'm excited. I fall into that age group, so I'm excited about it. That'll be fun. That's a good local concert that we have here in Southern California. We both, David and I, live in the South Bay area of Los Angeles. So thank you so much for carving out some time from your busy lawyering to talk to us. I don't know how much of Alan's cross-examination you were able to catch. Right now on the stand is kind of one of the more pivotal witnesses for the prosecution. Her name is Jen McCabe. I know that you know enough about the trial from having seen some of it the first time around that you know that she is important because she's one of the witnesses who Karen Reed contacted when she woke up in the morning. John O'Keefe is not there. She's in this full-fledged panic. She calls Jen McCabe's one of the people she calls. They get in the car. They're looking for John O'Keefe. They find him laying in the snow outside of 34 Fairview, where they had gone to that evening. Now, that's where the prosecution case and defense case take a big split. Defense case says she's dropped him off. He went inside the house. She never saw him again, never heard from him again. Next thing she knows, he's lying dead in the yard. Prosecution says, no, in fact, you dropped him off, but then you rear-ended him with your vehicle and then took off and later on woke up and realized how much you had hurt him. But Jen McCabe, I think, other than providing that general timeline for everyone, being someone who was there when John O'Keefe's body was discovered, she also gives what has become kind of one of the more central pieces of evidence in this case that the prosecution, the Commonwealth, definitely wants to drive home to the jurors, and that is that at some point that morning, Jen McCabe says that Karen Reed starts screaming, I hit him, I hit him, I hit him.
Which is generally a bad thing to yell over a dead body. Just
correct.
There's tip number 1.
Tip number 1, do not yell that over a dead body. Now, to be fair, the defense says that there's been many iterations of that statement, and that you can even take that same statement and not necessarily make it to implicate you. In other words, there's a big difference between I hit him and I hit him. And that is what the defense is kind of going with, is that she didn't say I hit him as a declaratory sentence. She's saying it as a question, and it might have been preceded by the word, did I hit him? And it might have been, could I hit him? Any one of those. But Jen McCabe, there's other witnesses, but she is one of the witnesses saying that this is what Karen Reed said. And she's kind of important because she knows Karen Reed. She was friends with Karen Reed at that time. So with that whole setup, my first kind of question is that, AJ, he's a tremendous trial attorney. He has gone very strong after Jen McCabe. And I believe that's because he has to make the jurors not just believe that she is mistaken, but that she's actually lying. And that's why he's going after her so aggressively. How, in your experience, how difficult is that? Because Jen McCabe's not this kind of imposing figure, she's not, some sort of criminal. She's a housewife and mother from that area, but he's going after her about as strong as you can go after a witness. Is that a difficult kind of tightrope to walk, where you're trying to balance both, zealously advocating, calling someone a liar, and at the same time just not turning jurors off to what you're doing?
Yeah, absolutely. Really, it's sort of they're making a bit of a Ron Burgundy point here, right? Because it's I hit him. Like,
Right,
they're
right,
really, where do you put the emphasis on the word I hit him?
right.
Um, and I think she's the watershed witness because, you know, if Karen Reed beelines for a snow mound that nobody could have possibly noticed other than the person that left the dead body there, and yells, I hit him, that in theory could be the beginning and the end of the case, right? Alternatively, I did just watch the last 15 minutes of Alan's cross of McCabe. In the last 3 minutes, and he was wise to ask the judge for a little patience before the lunch break because he wants that to be what the jury is snacking on during lunch. I think that cross was absolutely devastating. Um, she is reasonable doubt in her behavior around this time, and especially the fallout. And what happened, I haven't any idea, but I know that she is not being completely forthright with what she was doing and why she was doing it. Um, and so I think that's where he plants his reasonable doubt. That's where he plants the
You're
beginning of a
saying
conspiracy.
Jen McCabe was not being forthright.
I think that's right. I
Okay.
don't think the explanations of the phone calls, of the behavior, the was there somebody 34 feet away that might have been able to help? Can you think of anybody? I thought coming around it in a way where she was just going to look so silly to either not answer the question, or once she did answer the question, but sort of a no-win situation for a witness. So she's the beginning of, like you said, this is where the story splits, and he has to win this witness. To answer your question, eventually, it's like old times. Uh, you know, I think it's difficult in the sense that you have to be patient. When you have what appears to be a witness that people are not going to immediately dislike, if you have somebody that meets criteria, that is going to be sort of presentable as a nice person, you can't just stand up and start trying to throw haymakers and being aggressive and using a nasty tone and being impatient with them. You have to give them the rope to hang themselves. But at some point, if you're doing it right, that witness is going to hang themselves with all the rope you've been letting out. And I think whether it's because you're catching it out of the corner of your eye, or just because you sense it, or sometimes it's just because you trust that you've gotten the case there or the witness there, that's when you kind of take that turn on her. And certainly when he was asking those questions about, was there anybody on the block? Was there anybody 30 feet away? Who are you calling? Were those important calls? I mean, he is being hard, he is being mean. And if that jury still liked Miss McCabe and thought she was being honest, they're going to really dislike that he's doing that. My suspicion, and certainly his bet, is that he has gotten enough out of her to demonstrate that disingenuousness, which the jury hates. And now he has permission to go attack and to be nasty and to get the job done.
So I know you don't have the benefit of having watched the entire cross. I mean, we're going on day number 2 now. But I completely agree with you. I've said that many times. If the witness gives you permission, you can be about as aggressive as you want to be. And I like the way you said it. You got to wait for them to give you the rope to hang them. I'm curious, and I know you just watched that last of it. Do you, even in that last few minutes, do you feel like her responses, her demeanor was giving him that kind of permission? Because I kind of viewed it a different way. I'm not well, I guess I am disagreeing with you, but I guess my take was kind of like, he seemed more heated than she did, was just my general assessment of that moment, that he seemed far more outraged than she was giving him through her answers. But maybe you saw it differently.
So I guess the distinction I draw is that I think you're right. I think the emotional level, the tenor, she was she was not taking the bait to go back and forth with him, with the exception of the very end, where when he's really hammering the point that you didn't think to go get help and you were making these other phone calls to other people, and then the answer, instead of the answer just being yes, that's what I did, yes, and non-combative, it was, oh well, it's because you're and she starts
Yeah.
listing off
Yeah.
the
Yeah. Yeah.
evidence
Yeah. Yeah.
against the defendant.
Yeah.
And that to me is, at least if I'm Alan in that moment, I'm thinking, thank, I finally got her. I
Yeah.
finally got her to take some of this bait of going somewhere she really shouldn't have gone, and she was clearly coached not to go. But I think that I I think that it's a stylistic question, and perhaps it's a personality question of whether or not you have to mirror the witness's um, tenor. So, for example, I'm somebody that if I think I've got the jury to the idea that that person's being dishonest, I will get aggressive, and I will get aggressive in my tone. I really can't help it. Like at that point, that's who I am. I'm going in, and there's no way for me to get through an entire cross of the critical witness that I'm making out to be a bad guy without me getting aggressive. It's gonna happen. My hope is that I can wait till the right moment, right? So I don't think I have to match that person's tenor. In fact, I would suggest that maybe by matching their tenor, I'm allowing them to downplay the significance, because sometimes I think in your cross or your questioning, you know, the emotion you give is to tell the jury how important it is so that maybe they wake up, right? You got 12 people that are not all paying attention to the same level at the same moment. And if I turn myself up, I know I've got all 12 suddenly watching because they're like, okay, hold on, wait, what's going on?
Right.
Who said what?
Right.
So I think there's a place for it, but I think that's a stylistic thing. I think that I think wonderful attorneys that were doing a great job could take the other side of it and say, no, I always match, because I never want to be more aggressive than the witness, especially if it's a nice, presentable female and I'm an aggressive male. I don't like that dynamic. But that's kind of what I make of it.
Yeah. I I I agree with you that the best trial attorneys on cross-examination that I've seen do realize that there is a certain amount of theater in it, right? Like you have to know that if you're trying to make a point and you want this answer or exchange to to sit in the jurors' heads when they go back into that deliberating room, which may be weeks from now, by the way. So these moments need to remain in their head. That you have to be outraged and signal to them they should be outraged, right? If you aren't putting the exclamation points in the paragraph, they're not going to get it. So he is, I think, a master at signaling to the jurors of I'm outraged and so should you be. And as long as they're along for the ride and agreeing with him, he's doing a fantastic job. It's interesting what you said about Jen McCabe right there at the very end, because she did give an answer where he said something along the lines of you didn't feel it was about whether or not anyone inside of the home was in danger. Excellent point,
Sure.
right? You're
Hmm.
finding a dead person outside of someone's house. You have loved ones inside of that house. Why didn't you take the logical step of making sure everyone inside the house was safe? And her response was, and I think this is what you were talking about, was I wasn't worried because she said I hit him. She had a broken taillight. We're looking at it, he never came inside the house. And she kind of gave the bullet points of the prosecution's case. And I thought at that moment, if the jurors are leaning towards the prosecution on this, they probably love that moment for her. But if they're leaning for the defense on this, I think they're doing exactly what you just said and saying, boy, this lady can't answer a question straight, can't she?
I think that's right. I mean, very much, and I haven't followed it enough to know where the jury is, but there comes a point, I believe, in every case where one side a dead man walking and they just don't know it yet. And the
Yeah.
jury has probably made up their mind, and there's not much that's going to happen unless you've got some sort of aha moment, which is really an exception in trials. It's kind of reserved for Hollywood, that the jury is sort of is pulling one way or the other. But I think that, you know, to some degree, and you know this obviously, it's all Alan needs is another hang. I mean, how many times does this thing hang before a deal gets cut that is, you know, can be stomached by everybody involved? So he just needs that one, right? And so I think he's got us. I mean, the way I put it is this: if in that moment that I just watched, the jury did not like what he was doing with that witness, then he's a dead man walking. And there was never going to be any, he had already lost this trial at some point. Like, it has to be the case that he is at least starting to bend them his way, and that is actually making progress towards that goal, or he lost his trial some days ago and we'll never know exactly the moment. But that's kind of the way I would look at it, is that it must be the case this is working, or I'm dead already. This to me seems like too critical of a watershed moment in the case.
Yeah. Yeah. And when you're in it, you know this, you kind of don't know you're in it. I mean, you don't know,
Yeah.
are you the dead man walking, or is it the people sitting on the other side of the table? And you try your best to read the jurors and pick up on what they're doing. And I always say the favorite pastime of trial attorneys is reading the tea leaves of what the jurors are thinking. And there's all these theories about eye contact or no eye contact, or who's along board. I've had juries where they smile at me every time they see me. And every time walking in the morning, I'm getting big grins. And when I'm speaking to them, everybody sounds like they want to have coffee with me afterwards. And they go out and completely, convict my client or do the opposite of what I was hoping they would do. So there's just no way of telling.
Yeah. Bruce Willis didn't know he was dead until the end of the movie, right?
Right. Yes. It's a sixth sense
It's
moment.
the end when they find against you and you go, oh, because it didn't just happen in that moment, and it probably didn't happen an hour ago. It happened many days ago,
Yes.
and you're just now finding out.
Or in some cases, it happened in jury selection,
That's
right?
right.
I mean,
That's right.
you messed up with somebody who's on that jury, and you were never winning this thing from the jump. I know, again, I'm going to kind of tell you what Alan did, even though you weren't able to watch all of it, but get your thoughts on it. This witness, being as pivotal as this witness was, I think that Alan knew, to your point, he had to come out of this with a win. If he doesn't come out of this witness with a win, with at least some of those jurors, then the case might be lost altogether. So in part of his aggressive cross-examination of this person, and it wasn't just always fire and brimstone like you saw there at the end. Some of it was very calm and deliberate, but it was also very detail-oriented, and he split a lot of hairs. And there was a lot of questioning. Like, you've got witnesses who, by the way, Jen McCabe, she's testified at a grand jury. She's given statements to police more than once. She's testified at a first trial, and now she's testifying at this trial. So there's plenty of opportunity for her to answer the same or similar questions. And she's answered them sometimes in slightly different ways. And even when those different ways were slightly different, he would spend a lot of time talking about, you told the grand jury, that I'm trying to think of a specific example, but it came down to really kind of what I would consider minutia, but it is ripe for cross-examination because it can be considered prior inconsistent statements. How much of that in your practice do you feel is helpful, or does it begin to make all of your big points get lost in all of the points, because it not everything can be a slam dunk. And if you're trying to make every single point a slam dunk, then they miss the actual slam dunks. You know what I'm saying?
Yeah, for sure. I think that you've got to you got to pick and choose your moments, right? I think that, and I think back to our days as prosecutors, but even still now as plaintiffs counsel, I make this point that slight differences in the telling is not a sign that someone's being dishonest. In fact, it's a sign of genuine attempts to recall on different days. The sign of a lie is that it is exactly the same every single time it's told, because it has been rehearsed, planned, and planted. You know every single thing you've got to hit and exactly how you're going to hit it, because you've gone over it 1,000 times in your mind, because you know your something very important depends upon it. So that was always a point I made as a prosecutor. It's a point I make as a plaintiff's lawyer when the defense is pulling this tactic of splitting hairs like you're describing. And I think that it absolutely can begin to make it feel like there must be some weakness to this defense, because why are we going over these silly little points? And I think it is important to point out the discrepancies that matter. With that said, I was in a case when we were prosecutors where the defense had no defense, to be fair, but pulled out every single discrepancy. There must have been 25 little stupid discrepancies, and it absolutely fell flat. And it fell flat as they were doing it. You could see the jury shuffling and getting frustrated and shaking their head, and it just had no chance. I then watched another lawyer in a case I wasn't involved in directly essentially do the same tactic of going through. There was a video, and there was discrepancies, and there was multiple reports, and painstakingly going through every little thing that not a single one of them mattered. And he got a successful outcome in the defense of that case. So I suppose just mentioned that with the idea that I guess sometimes if it's done properly, it can work. But I join you that my instincts are you better just pick what's important, because if you start talking about what's not important, you lose the jury's interest. And more importantly, you start to signal that there's some sort of weakness that you perceive, and you don't want them to perceive that any sort of weakness in your case, right?
Yeah. And I don't even think it comes out of a place of laziness too, but I don't know if I've got the, unless a witness is just giving me nothing but softballs to hit out of the park, I would rather kind of get in, cause a bunch of trouble, get out, and feel like I left on some high moments than, go into one of these cross-examinations that last for hours and days, going over every little detail and every little discrepancy, because I feel like, well, then they're just, like anybody else, going to get bored and tired and over it, and all my good points might be lost in all of that. One thing while I have you that I wanted to ask you about, there's a difference in the prosecution this time around from the first trial. Big difference. First time around, there was the prosecutor was a guy by the name of Adam Lally, kind of like every prosecutor we ever worked with, just kind of punching
super dynamic.
Right. Just kind of punching his card. He just, got up there, just the facts, very monotone. I swear that guy's pulse didn't rise a heartbeat or two at all during that whole trial. But he did, I don't want to throw him under the bus. I felt like he presented all of his evidence. This time around, they've got a special prosecutor by the name of Hank Brennan, far more dynamic, very smart man, far more aggressive. But one huge difference that he's doing that wasn't done the first time around is Hank Brennan has gone through every media interview that Karen Reed has ever done. And she's done a lot of them, by the way.
Whoops.
I'm talking 2020. I'm talking Dateline. I'm talking a docu-series. I don't know if you caught it. That was on ID Discovery. It was like a 4 or 5 part docu-series where the defense gave nearly unfettered access to their entire team. And it was filmed during the first trial, was when they filmed all of this. That was released weeks ago, just before the beginning of the second trial. He's gone through all of that and cherry-picked statements here or there, which are objectively devastating. I know we got a lot of people watching, a lot of people in the chat who feel very strongly about this case either way. I'm saying, putting aside your feelings on this case, when you hear Karen Read say, well, I looked at him and he didn't look mortally wounded, and so I thought, maybe he'll be fine. Something along those lines. I'm paraphrasing, but she's talking about having witnessed him being injured after she left. She thought, did I clip him? I mean, these are like devastating type statements. And again, there's context that I'm sure, is surrounding all of that and everything, but he's played these clips. One, what are your thoughts on the fact that she gave these interviews? And two, how impactful do you think those short media clips can be on a jury? I don't know if you've seen any of them, but just from what I've told you.
Yeah, I've seen a couple of them. I think they can be absolutely devastating. These are words coming out of her mouth, the magic of television, right? You see her, she's saying it. It's, just simply damning statements, with the defense they're going with now. As to, I have a high opinion of Alan Jackson as a trial attorney and as an attorney, and but I don't know what on earth anyone would be thinking to let somebody facing criminal charges sit for interviews with the media. And if you do it, you sure as heck better win the first trial, because now here you are. And maybe they couldn't stop the release of that. Maybe they thought that it was going to generate more support. You've got sort of this crowdfunding angle that may be a consideration for the defense, as far as we need this thing to come out. I don't know. But those statements are terribly harmful. What hangs out here, right, is that, like, to me, there's this question that floats on both sides of the V in this case, which is, at some point, based on what she was saying in interviews, she was already planting a sort of vehicular manslaughter or accidental defense. And at some point, the defense shifted to more of this conspiracy. She didn't do it. Those are two very different things, right? And on the other side, what I thought, I watched some of that documentary, I followed this story, and I can't believe it baffles my mind that they're still going after murder. I just don't know how you make out the murder in this case. Did she clip him with the car, and is he dead? You got a puncher's chance at that. I think this case has got an awful lot of reasonable doubt. So I think the defense has got got an absolute chance. But it seems like both sides have flirted with, this was an accident, but neither side committed to it, which is sort of an interesting dynamic at play.
Yeah, I completely agree with you. I've said from the beginning, and it is funny because the defense, with the strategy they've taken, has had to abandon this. But I've said from the beginning that the weakest part of the prosecution's case is intent. You're right. Second-degree murder is really difficult for them to get to from where I stand, because now there are some voice messages that she leaves him, as soon as she's leaving the property, and they're horrific, and she's screaming at him and everything else. But she doesn't say something like, and I hope you never get up off the ground, and you deserved like none of that. Right. So how do you prove she intended to harm him, to kill him, to, injure him? But for vehicular manslaughter, you don't have that same kind of high hurdle of intent, and it can be an accident, and it can fall into, I don't know if he was mortally wounded, or may I have clipped him, or was I so intoxicated I wasn't quite sure what took place that night. So yes, I agree with you. The prosecution overextended themselves with charging here. Now we're used to that. That's kind of how they play this game, is they overcharge, go in hoping maybe the jurors split the baby, hoping maybe a plea negotiation takes place and they can dismiss the more serious charges. But with that being the weakest part, that's not the part that the defense went after. Because when you're saying it wasn't me, it doesn't matter her intent. And so they've abandoned that completely and went for this shoot for the moon defense, which is conspiracy and cover up and framing and all of that. And I don't think that they can pivot away from that at this point. Like you can't, it's not, well, I want you to weigh in on this. The idea that a defense can kind of present alternative defenses is not outrageous, but when your alternative defenses are, she had nothing to do with this, someone else did it, or if you believe she did it, she didn't know she was doing it. Like you can't play those two sides of a coin, right?
It's one of my favorite jokes was the defense lawyer who says that's not my client in the video, but if it is, they were acting in self-defense. So you can't have it both ways. Is it not your client, or are they acting in self-defense?
Right.
But I agree with you absolutely. I think what I would hope to see, or what I would be doing, I would like to think I'd have done it in the first trial, certainly by the second trial. I do think there's room, and it's not the easiest task, but I do think there's room in his closing argument this time around to present the conspiracy and the theory they have sort of staked out and hitched their wagon to as more of a story of reasonable doubt, instead of trying to prove the actual conspiracy and allegations they assert. Because it's two different things. I'm telling you a story in the things that make up my story, the facts, the evidence, the way the witnesses testified, the things they said. All of those things create reasonable doubt. I believe they make out a conspiracy and an alternative explanation. But whether or not you go all the way there with me, they are reasonable doubt, ladies and gentlemen. So I would really try to encourage the jury, or educate the jury, or let the jury know you don't have to commit to my theory of the case. You just have to see the reasonable doubt. We can both see the reasonable doubt and let it lay, and you can stop there. I take it a step further. We think the police did this, covered it up, or the families of the police, blah, blah, blah. But you can just stay there. You can stay with, you know what, you're right. All of these questions have no answers. And if they have no answers, that is reasonable doubt. And so it's a much harder job. But I think based on the way the last trial went, based on the way this trial is going, based on her statements to the press, I would go full tilt into a reasonable doubt argument instead of, please believe me when I tell you it was these people over here.
Yeah. Because the other risk in that, and I don't care how you can say it till you're blue in the face, that the people have the burden. The prosecution has the burden. I don't have to prove anything. I could sit on my hands. I don't have to ask one question. They have to prove everything. Presumption of innocence. Before we begin, she's innocent. All of that, all day long. But when you start to make an affirmative defense, when you start to say, not only is my client not guilty, and not only do they not have proof beyond a reasonable doubt, but I'll tell you what did happen.
Right.
You begin to assume some burden, despite the instructions. Jurors naturally go, okay, well then prove it to me, sir.
You don't have a burden to open your mouth, but you better believe the minute you do, you better back it up, right?
Yeah.
And I think that's where he finds himself. And listen, and I think, and again, I don't know everything about this case, so let's take everything I say with a grain of salt, but certainly this, we may never know the absolute truth. And like, two things can be true, right? It can be true that she clipped them. It can also be true that there was some reason these witnesses that are surrounding this home and the people in the home are acting squirrely. Mm-hmm. And they may or may not be directly related. Like it could be the most wild explanations ever. We could find out, it could have been that they were running guns out of that home
Right.
Cops sometimes run guns and drugs. And if there's a dead body on the front lawn, we better figure out how to get rid of it. We're not going to worry about the body. We're going to worry about the drugs and the guns. And then we will worry about I mean, you could think of 1,000 wild examples, but there is a universe where and we're never going to get it. But that woman, McCabe, her actions don't make sense. And I don't think she's being forthright. I just don't know why. Is it because she killed him or was a part of killing him or a part of covering it up? Or is it because she was aware of or involved in something completely different that was taking place on that property that she was worried about? I don't know.
Right. Yeah. No, they're not mutually exclusive. That one doesn't, the absence of one does not equal the presence of the other. Same goes, and we haven't gotten to that part of it yet, but you may remember from the first trial, the investigation in this case was a never-ending clown car of problems. I mean, from collecting forensic evidence in Solo cups to then putting it inside of a grocery bag to using a leaf blower to clear the scene. I mean, it was just on and on and on problems. And I said the first time around, and I'm sure I'll say it when it happens this time around, is that they are not mutually exclusive. You can have a completely sideways, god-awful investigation and still a very guilty person. And It's like that just because they screwed up the investigation does not mean there is not still evidence that somebody committed a crime. And just because the investigation may have been perfect doesn't necessarily mean that that person committed a crime. So they're not mutually exclusive concepts. But I agree with you that is where the defense and where Alan has to thrive, right? Is in that, well, it is bizarre. Why didn't you go contact the people inside the home that morning? Why didn't the people inside the home come out that morning? Why is everybody in Canton butt dialing each other in the middle of the night? There is a lot of curiosities and confusions and unknowns, and he's got to live in that pocket to make it sound like, well, it's not just bizarre, it's planned, it's on purpose, there's something behind all of it.
And it starts, the very first plot on that graph is, you didn't say officer down on 911. That's his first plot. And then it's going to go on everything that the investigators did wrong or didn't do. And what he's driving at is that this was a police officer. There is a heightened level of care that should have been, that you would expect and is applied to his investigation, that is applied to his emergency response. And at no point do you see any signs of that. In fact, you see the opposite: incompetence at every turn, or what they want you to believe is incompetence. And he's going to use that to paint this picture of it. It cannot be the case that this is all coincidental incompetence. There's too many actors. There's too many mistakes. This is all purposeful to never get to any real conclusion other than the one they want you to believe, which is Karen Reed clipped him. And I do think it's a great point of because I'll say this: we were prosecutors for 7 years or so. I haven't been in that office since 2015 or something. If tomorrow, God forbid, you or I get hit by a car and I call 911, I'm going to say, officer down. And I'll deal with the consequences later, because I know from my time in the DA's office and working with cops that if I say that, they will come quicker. I don't think I would die on that hill to the point I would use it if I was in an emergency situation, and I'll deal with the consequences later. But so this idea that she didn't think, as someone that is like sort of law enforcement adjacent, that she didn't think to say, this isn't just anybody down, this is an officer down, does start to bend the credibility. And then you start pointing to all these other things in the investigation, which I think, clown show is about the nicest way you could put it.
Yeah. My friend, you're an absolute champ. I'm sure I owe you big time. I'm sure you're going to remind me that I owe you big time over this, but I appreciate you taking some time to chat with all of us. I hope you'll do it again.
Absolutely. It's been a pleasure. I'll see you soon.
Before I let you go, tell folks where can they find you if they're looking for an attorney. Do you got a website, social media, anything you'd like people to know?
I do have a website. It's Gammill.law, so www.gammill, GAMMILL.law. And I'm on Instagram. I think my handle might be Gammill_law, Ron Burgundy. But I'm definitely out there on social media. You guys should go look at it. It is great.
It's chef's kiss. All right. Thank you again. I appreciate it.
Take care, buddy.